All right, welcome back in here to Live Now from Fox. I am Andy Mack. Let's continue our coverage of the top story. Jury selection is underway in Fort Pierce, Florida. This involving the case with Ryan Routh, the would-be assassin there, the second assassination attempt on the life of then candidate Donald Trump. Let's be joined right now in Fort Pierce, Florida by Fox News correspondent Rebekah Castor. Rebekah, thank you so much for joining us here. What can you tell us about the proceedings? We know the defendant is defending himself.
Well, Andy Mack, I can tell you that jury selection just wrapped up here for the day, and it got off to a rocky start earlier when the judge threw out multiple questions that Ryan Routh wanted to ask potential jurors. On the first day of jury selection, the man accused of plotting to kill President Trump at a Florida golf course appeared in federal court as both a defendant and his own representation. Ryan Routh wanted to ask potential jurors about the war in Gaza, the proposed U.S. acquisition of Greenland, and whether they would stop if they saw a turtle in the road. But Judge Aileen Cannon called those questions irrelevant.
The judge is going to continue to come back to, does this make a difference in the outcome of the legal questions here?
In July, Judge Cannon signed off on Routh's request to represent himself, but his time in court has already created issues. In one filing, Routh requested strippers and a putting green to practice for a golf match with President Trump.
This is an exercise in the procedures of trial and the constitutional rights that he has to make sure that if they do get a conviction, that it withstands the appeals.
Routh's former lawyers, public defenders, are on standby throughout the trial. Each side will question 3 sets of 60 people a day until they find 12 jurors and 4 alternates to determine whether Routh is guilty of multiple federal charges.
His whole motivations through all of this is to make a spectacle of whatever he can in the name of trying to be in opposition to Donald Trump and ultimately to try to assassinate him.
21 of the potential 180 jurors were dismissed by the judge today. Still a lot of people to talk to, and our producer in the courtroom said it was clear at one point that the judge was becoming frustrated with Ryan Routh. Earlier today, he said he wasn't able to go over the jury questionnaire, even though he was given 3 hours to do so because he didn't have a pen. Andy Mack, back to you.
It's so very interesting. In this case, obviously just getting started, you can hear the frustration coming out of the courtroom of what's to come over the next several weeks. Was there anyone on the ground? Is there any protesters, any people in favor of President Trump? Are there any people there kind of watching and waiting outside the courtroom?
Honestly, not yet. This is just getting underway today. From our point of view, we haven't seen any protesters, but a long way to go here. We'll see if this gains some traction over the next few weeks.
All right, very good. Just day number 1 there of jury selection. Rebekah Castor, thank you so much for your time. Great reporting, as always, here on Live Now. All right, thank you so much. All right, this is the top story that we're following, jury selection involving this Ryan Routh in Fort Pierce, Florida. This was against the assassination attempt, the second assassination attempt of Donald Trump, then the candidate. A live look right now at the White House. Routh is charged with attempted assassination of a major presidential candidate, along with assaulting a federal officer and a string of gun violations. Prosecutors say Routh spent weeks plotting the attack, even camping out near Trump's golf course for 12 hours with a rifle. A Secret Service agent spotted the weapon and opened fire at Routh, allegedly aiming at him, forcing Routh to drop the gun and run. Let's continue this conversation here on Live Now from Fox and bring in legal analyst, friend of the program, Nicole DeBorde. Nicole, thank you so much for joining us here on Live Now from Fox. And this feels like an open and shut case right now. Is jury selection the most critical, the most important, pivotal time for this case?
It certainly can be an incredibly important time, and it's one fraught with danger for a court when you have a pro se defendant. Not only does the prosecution have to tread lightly and make sure that they are doing everything that they possibly can to dot their I's and cross their T's, but the judge has to balance the idea of being patient with someone who's clearly not a lawyer, but with smoothly allowing the normal court processes to take place, such that all of this accused person's rights are protected and that he gets a fair trial under the law.
Yeah, that is going to be a topic of conversation. The fact that Ryan Routh is representing himself, and what should we expect? Should we expect the unexpected, and how will the judge manage this? How delicate can it be?
Well, federal judges, as we all know, have an incredible amount of discretion in how they run their courtroom and what kinds of questions they'll allow, for example, in voir dire, and what they can direct the attorneys to do in a case, and witnesses. Anyone who is coming into the courtroom is subject to the rules of what the court sets out, so that we can have a smooth procedure, so that the trial can run from beginning to end in a way that everyone can have confidence in the result. But the problem is when you have someone who's not a lawyer, who has a history of, in this case, what seems like severe mental health problems. This is a real balancing act for the judge. So in the answer to the question, what can we expect? I think we've already seen some of what we can definitely tell is going to be unusual, that very chaotic questions, very politically charged questions that this accused is wanting to be able to ask jurors. I think that this is going to be a messy process from beginning to end.
Yeah, that is to say the least. And you heard some of those requests from Ryan Routh during that package by Rebekah Castor. But of course, Routh submitted some questions. The federal prosecution team objected to all of them, including one that said, if you saw a turtle in the road, would you stop and move it? So obviously very peculiar, to say the least. In terms of the scenario, what are normal questions?
So normal questions that the court will allow are questions that will help the parties understand whether or not potential jurors have preconceived notions about how they would vote in a case, how they would find whether a person is guilty or not guilty in a case, or how they might consider certain legal issues. There may be some people who have had things happen in their lives that create a bias or a leaning against one side or the other, and the parties have the right to know about that, so that when the evidence is brought into the courtroom, that's what the jurors use to consider their verdict, not how they feel about something that has nothing to do with the evidence that's been presented in court.
Yeah, it's so very interesting, and some of those questions will be asked, hopefully more than the latter that I just brought up. But how messy could this jury selection be? Because they can't not tell Routh to say something. He might just say something. How messy could it get in that regard?
I think it get very messy. I mean, as you heard earlier in the reporting, we have heard everything from he's asked for strippers and, time to practice golf, and couldn't review the jury questionnaires in the 3 hours which were allotted to him because he just didn't have a pen. So just because the judge orders it, I mean, the rest of us out here understand the authority that an Article III judge, a federal court judge, has over the courtroom. But this individual has to not only understand it, but he has to comply with what the court's instructions are. So this judge is going to have her hands full in terms of trying to make sure that this person follows the rules and yet has his day in court.
And this judge says it was a bad decision to potentially have himself represent himself in this case. But there is going to be a quote-unquote standby counsel. What is the likelihood that they step in, and can the judge ultimately make the decision that they need to step in?
It can happen under certain circumstances. And let me tell you, being standby counsel is just no fun at all. And the reason I say that is because these are, some prepared, smart lawyers who know how the process works, and they just sit there with their hands tied as, whatever this pro se defendant does happens in the courtroom to sort of lay this path that they, if they are called upon by the judge to step in, have to continue down if they are asked to do so. It is a rough ride, and sometimes it's very difficult to get a case back on track once it's been started by someone who's pro se.
And if they are, like you said, it's going to be very difficult because you're biting your tongue at every moment at everything Brian potentially says. Are they basically just sitting there? Are they on deck in terms of this inside of the courtroom?
They're on deck. They're sitting there, but they're paying attention. They have to understand everything that's going on in the courtroom, but they're not participating at this juncture. They're waiting to be called in if something happens, which means this accused, this defendant, can no longer, under the rules, function as his own lawyer. And then what will happen, or if he makes a request to have them come in and he understands that he is no longer going to be the lawyer or functioning as the lawyer, then they could be asked under certain circumstances to come in the middle of trial to try to take this thing across the finish line.
And I want to ask you, because if they do step in, there have been some ideas floated about what the defense might look like in terms of the fact that he did have there kind of a manifesto of sort, but there's also an argument about the viability of the gun and the viability that this individual was to be able to shoot the gun. Does that have any solid standing in your eyes?
I mean, it's possibly something that the jury would need to consider, that the gun didn't function at all, could have never functioned, that the defendant wouldn't have known or did know that it could not fire and was really not trying to cause harm, but instead tried to make some kind of political statement as opposed to actually assassinate the president. It's possible that this could be a matter that the jury would find relevant in their determination as to whether or not this accused individual is guilty of the charged crime. So that could matter. Is it going to be enough, or are people going to be bothered, as we all might assume they should be, that someone was pointing any kind of potential weapon in the direction of the president? This is something that this jury is going to either have access to the information because the defense is going to be successful in laying it out, or they're going to be missing it because this pro se defendant is not capable of presenting legal defenses that can actually attack the charges in the case.
Yeah, that is a very good point. And of course, being charged there with the attempted assassination of a major presidential candidate. Of course, Trump unlikely to take the stand. But is that a possibility at all in your eyes, to see Trump there in Fort Pierce, Florida?
I think it's highly unlikely. It's certainly possible. I mean, it's not something that the government needs to make their case. I mean, the president was completely unaware at the time that this was happening that there was someone lurking off in the bushes, potentially setting up to make an assassination attempt. So it's possible and likely that the prosecutors in this case could carry forward without need of him coming into the courtroom, which would be quite the spectacle and maybe not necessary for the government to prove the elements of their case.
All right, very good, Nicole. Anything else that we're missing? Because this is obviously a very important, very high-profile case with a very interesting, peculiar individual. I said that word a time or two. Anything else that we're missing?
One of the things that I have been waiting on, and I'm a little surprised that we have not seen at this juncture, is that there really hasn't been a report or a request to have this defendant evaluated for his mental capacity to be able to stand trial. Is this someone who is even competent or sane, for that matter? Is he someone who should be in the position to be assisting in his own defense, or in this case, conducting his own defense because of his mental condition? It's possible that we could, at some point during this trial, see either the court or the prosecution or someone else who is a party to this case make a motion that the court, and the court could do it on their own motion, have this individual evaluated to determine whether or not this should even be proceeding until they know that he's indeed competent and sane. And
we've already seen some comments made by Ryan Routh that are obviously illogical. They are without reason. They don't necessarily comply. What is the bar, though, for that to reach that level where they potentially need an evaluation to see if he is competent and can go through with this?
Well, one of the considerations is whether or not the person who is facing the charges, who's the defendant in this case, had the mental capacity to understand the difference between right and wrong. And that's an overly simplified version of what is at stake. But it may be that he does not have the capacity. And if there is something that arises in the courtroom that causes the court or even the prosecutor to believe that this defendant's beliefs are completely untethered to reality, and he doesn't have the capacity to perceive information in a way that helps him discern what is right and what is wrong, and whether or not he knows that he could have even violated the law, then that needs to be evaluated. That needs to have some sort of a doctor come in and give us a professional opinion about whether or not this person is competent to stand trial.
All right, very good. Jury selection underway today. That should take a couple days, and then the trial 2 weeks long is what's expected. Nicole, thank you so much. I appreciate your time, your insight here on Live Now.
Thanks for having me.
All right, thank you so much. All right, great conversation there. As always, a live look in Washington, D.C. at the White House. Of course, this trial taking place in Fort Pierce, Florida, down as he was staked out in the bushes outside of one of Trump's golf courses there for the second assassination attempt back in September of 2024. I'm Andy Mack. We're back after this.